Hello friends, Namaskaram, how are you? Myself is Dr. Soni. I am a defense counsel. In today's class, I will discuss about section 349 of BNSS. The said provision is quite common concerning the cases of Prevention of Corruption Act. Whenever we get a notice from the ACB or CBI or police regarding the voice sample, we got panic. We think that there is a notice and we have to give the voice sample. In case it is not given in that scenario, they may move to cancel our bail. And apart from that, the court may draw the adverse inference. In that scenario, what we can do and what will be our rights. In absence of knowledge, you get panic, but there is no need to get panic. First of all, we have to understand what section 349 of BNSS provides. It says, the magistrate of first class, for the purpose of proceeding or investigation as per the protocol of BNSS, if things fit or satisfied that it is expedient to do so. In that scenario, the court may direct any person, including the accused person, to give a specimen signature or finger impression or handwriting or voice sample. So, by the bare perusal of section 349 of BNSS, we could say that for the application of section 349 of BNSS, the satisfaction of magistrate is sine qua non. The police could not exercise the power of providing the voice sample as per section 349 of BNSS, and police means and include ACB, CBI or vigilance also. So basically, I want to clarify that the discretion is to be exercised as per the sound principle of law. If the application is vague, there is no specification, there is no relevancy, and even there is nothing to show to the honorable court why the power is to be exercised, in that condition, the court may reject the application as per the protocol of section 349 of BNSS. So basically, we have to emphasize on the word may and satisfaction. And these two parameters are key performance indicator of section 349 of BNSS. And apart from that, the second part specified that if the order is made, in that scenario, the person against whom the order is pronounced shall be produced or shall attend the court at the time and place specified in such order, and subsequently he shall be bound to give the specimen signature or finger impression or handwriting or voice sample as per directions. So simply we could say that in first part there is a discretion and in second part there is compliance. So second part is mandatory while first part is discretionary. And apart from that, the concerned court is bound to follow the judgment of Honorable Supreme Court, that is Indrajit versus Santosh, in which the guidelines are propounded by Honorable Supreme Court regarding reasoned order. If the order pronounced does not contain any specification, any reason, in that scenario, the order would be illegal. So if there is no compliance of judgment of Honorable Supreme Court, an order is passed in limine and there is no specification, there is no reason, in that scenario, we could easily challenge the order. And apart from that, we may peruse section 393 of BNSS, which mandates that the order passed must reflect the reasons. Apart from that, there are two provisos. First proviso submits that no order shall be made under section 349 of BNSS if the person is not so arrested. So basically, it is the negative trade and it is in the favor of the concerned accused. And the further proviso says that even though the accused has not been arrested, the court may, for the reasons to be recorded in writing, order any person to give a specimen of his voice sample. So basically, we could say that the powers are discretionary. Number two, if the accused is not arrested, in that scenario, the power will not be exercised. And apart from that, if the accused is not arrested and even though the order is required to be pronounced, in that scenario, the concerned magistrate is required to record the reasons and satisfaction. If the specifications mentioned in section 349 of BNSS are not complied with, in that scenario, we may easily challenge the proceeding. So it is quite clear to us, the police could not give us a notice. If there is a notice, in that scenario, we may file the objection as per section 349 of BNSS by submitting that you are not having the power and you inter alia overstepped the jurisdiction. In that scenario, even though there is refusal, the court may not draw the adverse inference as per the mandate of section 119 subclause Z of BSA. So I have specified you the scope of section 349 of BNSS. And apart from that, we have to understand that recently Honorable Gujarat High Court in its judgment dated 27th of Feb 2026 specified that the provisions of section 349 of BNSS are required to be complied with if there is any diversion or deviation and there is no justification. In that scenario, the proceedings are abuse of process and liable to be set aside and discarded. See you in the next chapter. Till then, Har Har Mahadev, Jai Shiv Shambhu.